Hi, good morning, good afternoon, good evening to wherever you are in the world. We're very, very glad to have you with us. As you can see, the familiarity of the face is a little different for this episode. Unfortunately, our favorite host, Omar, could not be with us today, but hopefully he'll join us again in the subsequent episodes. And welcome to Jus Cogens, the International Podcast, episode 17. Today we have with us a very distinguished fellow of young professionals who have formerly served as judicial fellows with the International Court of Justice. And we're very, very glad to have you join us. So thank you for being with us. What we are going to do is maybe we can start off with an introduction across the panel. So I'll perhaps go over it alphabetically and start with Amir, then Beatrice, then Camila, then Shashank. And then we can get into the thick of things and get things rolling. So Amir, the floor is yours.
Sure, thank you so much. And thank you, Faris, and everyone for having us on the Jus Cogens podcast. We're really excited. So my name is Amir Farhadi. I'm originally from the United States. I was able to participate in the Judicial Fellows Program in 2018-2019 as the fellow from Harvard Law School. I had originally done my undergraduate legal education, my first degree in law, I should say, in France at Sciences Po Paris. And I worked at the court with Judge Giorgio Gaia from Italy. And I'm currently, after leaving the court, I returned to the law firm that I was working at, Deckard LLP in Washington, where I practice investor-state arbitration. And I would just say, I think maybe on behalf of all of us, that we're really excited to talk today about the Judicial Fellows Program and to help promote it. But of course, we're appearing here in our personal capacity and giving informal advice that doesn't represent necessarily the rules and conditions of the program or the position of the court.
Thanks. I'm Beatrice Walton, and I am also a judicial fellow from the year 2018 to 2019. I went to the court as the fellow from Yale Law School following my JD degree. I also have a master's in international relations from the University of Cambridge. I worked at the court for Judge Kirill Gevorgian, as well as more briefly as an assistant to ad hoc Judge Skotnikov. Thanks so much to the Jus Cogens podcast for having us on today. We're really excited to talk.
Hi all, my name is Camila Mourinho and I am a Colombian attorney. I serve also as a judicial fellow from the same year as Amir and Beatrice, 2018-2019. And I work with Judge Patrick Robinson. I was sponsored to practice to do this fellowship by Stanford University after finishing my LLM program. Thank you very much for having us, and a great initiative.
Hi, I'm Shashank Kumar. I'm an Indian lawyer. I was a judicial fellow at the court from 2012 to 2013. So about 5 years earlier from the other participants. I was a fellow from Yale Law School, where I completed my LLM in 2011. I served as the fellow. Well, at that time, actually, we'll probably get into this, but at that time, the program was called the University Traineeship Program. And I served as the trainee for Judge Donahue from the United States and Judge Shui from China, Vice President Shui now. And now I am at the World Trade Organization, where I used to work for the appellate body, but now I assist panels in the settlement of world trade disputes. Thank you for having me.
Right, so having finally introduced everyone, so I'll get back to Amir. So Amir, if you could just give a brief introduction of what the Judicial Fellows Program is, and maybe just on that note, you would start off with the discussion and what sort of the application process looks like, particularly in Harvard Law School and generally as well.
Sure, of course. So the Judicial Fellows Program originally, I believe, as Shashank mentioned, was originally known as the University Traineeship Program. And I think it started in the early 2000s when there was an idea to help bring over some graduate students in law from, I believe, NYU was the first participating university, in order to support the judges with their work in legal research and writing. And the program started there, and it continued on for several years. And then it, as the court's sort of docket started to fill up and become busier, the court, actually, I believe the registry of the court proposed to the General Assembly to create a budget for permanent law clerks to also assist the members of the court. And so now you have a program which coexists alongside UN official ICJ positions that are referred to as P2s. And those individuals, there are 15 of them, they assist the judges. And then there are also 15 judicial fellows who also assist the judges, but will come through a partnership with various universities across the world. And so the partnership with the universities who are essentially responsible for providing the funding for the fellowship and helping in the selection process, which I think we'll discuss a little bit more in detail in a moment. But the universities will fund these positions, which are 1 year long. And through that, universities, it's currently open to any university that is willing to participate across the world, provided that they can provide the necessary funding for fellows. So that is something that I believe is different from in the past. In the past, I think it was kind of a small number of universities that had joined on an ad hoc basis. But now, as of today, it's really open to any university to participate. That being said, there are a number of universities that traditionally apply to participate in the program every year by putting forward candidates or a candidate. But universities are free to participate, and there is on the website of the court sort of instructions both for applicants and for universities that are looking to sponsor a fellow.
And perhaps as a follow-up, Amir, and this also anybody else who wants to pick up on the question is, what is the sort of individual criteria to apply for the judicial fellowship if a student wants to apply for it in your university and indeed in the other universities as well?
Sure, I can answer quickly and then maybe throw to Beatrice or the others. So I think you can think of the application process and the criteria. It's sort of a two-tier process, really, because you have the sponsoring university that has to provide the sponsorship. Each university will often organize its own internal selection process in the first instance. So that is done differently for each university. For example, at Harvard Law School, they put out, it's the public interest advising office. They put out a call for applications. There's a committee of faculty who will then review the applications, and they select one individual to propose to the court. Other universities will select multiple candidates. A university is allowed to, I believe, propose up to 3 different candidates. So once all of these participating universities, which are required to, as we said before, undertake to provide funding for the fellowship, once those universities have submitted, and it is actually the university that sort of formally submits the application on behalf of the fellows. Once those applications are submitted, then the court will begin its own selection process out of those out of those many applications from many universities, and in order to select the 15 individuals who will assist the 15 judges of the court. So really, I think that if, for the listeners out there, I think you have to bear in mind that when you're applying and trying to put yourself in the best position as possible to be considered for the program, bear in mind that, you have this sort of 2-stage process. So you need to keep in mind sort of the audience of your university and securing their sponsorship, but then you also need to be selected by the court as well. So sometimes it's different criteria that are applied, and it'll depend on each university.
I could just say something about something that Omar touched on, about the origins of the program. And again, I happen to be an artifact in this conversation now, I realize, because 2012 fellow, right? But it's very interesting to me as to how the program's gone from being so informal to a day today when we're having a podcast about it, and it continues to remain in existence, despite the fact that, as he pointed out, the P2 positions have been approved by the General Assembly. And in fact, not only has it grown in its inclusiveness in terms of universities, I believe the program started with a few law students, or well, recent graduates coming to the court, serving in a pool that were assisting the entire court. And then progressively, individual judicial fellows or trainees, whatever you want to call them, were assigned to, say, 4 judges, and then they were assigned to 2 judges. And now you have a situation where there's an individual fellow for each judge of the court. So I mean, the court clearly sees some value in the program, and I can certainly attest that I think it was a great experience. So that's just
if I could just jump in on that as well. One of the really interesting things that happened actually last October was that the president of the court, Judge Youssef, asked the UN General Assembly to consider a trust fund for the Judicial Fellows Program. And so one of the benefits of that, if it were to come into fruition, would be that it would potentially alleviate the need for a university to itself fund the Judicial Fellow. And the hope there is that then the program could expand to even more universities around the world and to encompass, a much more diverse set of nationalities and universities than has already been represented. So, when we're talking about the history, it has tended to be the case that a lot of judicial fellows have come from American universities because there tended to be the funds available there. That said, the court, even among the applicants from those schools, did tend to, if you can go on the ICJ website and look up alumni and their nationality and university, it did tend to take a lot of students from the LLM or the SJD program, and so that helped a bit with diversity. But the goal, I think, at least in my opinion, would be to hopefully have something like this trust fund so that, it's not just the same 20 to 25 schools every year applying, but that really anybody from any university would be able to have funding. So that's the goal, and we'll hope to see that come into fruition.
I have an interesting story on that, because at that time when I was at the court, they weren't really having a conversation about a trust fund. So all the trainees and all the alumni that we could at least gather, at that point, there was no list. We sort of tried to come up with a fund, a crowdsourced fund that we could create to fund some people from, say, the developing world or the majority world or what have you. Of course, it didn't take off because the court isn't just going to take, money from judicial fellows existing or prior and give it to new ones. Obviously, that raises lots of questions of propriety, but it was something that was thought of. And on Judge Youssef's proposal, it was interesting because in his speech last year, he said that a proposal would be presented to the General Assembly early this year. And I tried to do a bit of research before this discussion. I wasn't able to find a proposal that was actually published, that was presented to the General Assembly. So, but I mean, it is, I mean, I think the point that Beatrice makes is obvious, that in the early years, the program was really limited to Western universities and non-Western graduates who happen to do LLM in Western universities and come through that path,
Yeah, maybe we can also continue to have a discussion about the representation aspect in the fellowship itself, and how it was with your interactions, collective interactions with other fellows, and which nationalities were they from, and how that whole experience was a little later in the podcast. But perhaps I can pose the question to Camila as well. Camila, what was your experience insofar as the application process was concerned? And what do you think, in your opinion, is the value or the importance of obviously a solid academic record and background?
Well, my experience in the application process was, I learned from the learned from the program during my LLM year. So I didn't knew it before it. And all my career I have been a public interest attorney, and I focus in international law, primarily in the Americas. So for me, it was a great opportunity to apply during the LLM as to continue my career in international law. As Amir mentioned, every university is different, and Stanford Law School had its own way of presenting the candidates before the court. So it was also the Public Interest Office that launched the information to the students. They gave us a deadline. We presented our information, and then I heard back that I was elected for the program. So it was a really nice surprise, especially because I can say that I was doing my undergrad here in Colombia. I did a focus in public international law. However, during my practice years after the undergrad, I was more focused in the Inter-American system of human rights and maybe in business and human rights before the US tribunals, because I work in an NGO. So it was that mixture maybe of profile that maybe created an outstanding profile in order for the court to be selected, because I don't know how well, as Amir also mentioned, there are two steps to be selected for the program. So yeah.
I guess another point that bears mentioning in my experience on this point, and for the viewers, I guess, is the fact that not every fellow that I met was steeped in the law and procedure of the ICJ. You know, the court was actually quite open to getting lawyers with different backgrounds, not entirely public international law, human rights, business and human rights, international corporate law, etc. Which to me was, again, I think it signified that it was open to engaging with lawyers working in these fields, and which was nice, because everybody, when you get together, had great ideas.
So Shashank, I think you raise a very interesting point. So just to sort of see, is there a specific criteria in terms of prospective applicants that they should, for example, be aiming for? So for example, do you think academic record, for example, is that important? How important are prior publications? How important would it be to have sort of a strong CV which sort of ties into international law? And finally, how important is it to have like a strong writing sample that you're going to be submitting for the application? So if you could maybe speak to some of the things which are common to all universities. So for example, everyone submits a CV, everyone submits reference letters, everyone submits writing samples. So maybe if you could just give some advice in that context to prospective applicants to sort of the do's and don'ts. So yeah.
I guess it's obviously difficult to attach weight to these things in the abstract, right? Every applicant's profile will differ, and at the end you've got to play to your strengths. But I guess the one general point to make at the beginning is, at the outset, is the fact that public international law is generally an academic heavy field. And it does sort of privilege if you can write well, if you can research well, if you have a few publications. So by and large, sort of generally speaking, as a rule of thumb, I'd say that publications are definitely useful. Publications on matters of public international law are definitely useful. Although I do not remember if what the court asks for are publications in its application process, but I think they are writing samples.
Through the CV.
So it's not necessary. I think what's obviously necessary is that, so you need to submit a writing sample to the court together with your CV and reference letters. And this may go through your university, and they may have a selection process, or it may go directly to the court. But the writing sample obviously has to be very good. It helps if it has to do something with the court's work or with public international law, I believe. Reference letters, of course, are extremely important. Usually, as I think with most reference letters, they should be written by people who actually know you and your work in the field and have engaged with you and know your abilities. Getting a really famous name to write a reference letter while they are not fully aware of your work, again, may not be the best approach. And then in terms of CV, academic record, of course, I think matters a lot. Languages matter a lot. Diversity is a factor that I think the court actively considers in its selection process. Bear in mind also that this is an entry-level position. It's not a professional position in that a P2 position now exists. So it's almost to give applicants or selected applicants a flavor of the ICJ and to turn them into, say, ambassadors of the institution in their respective countries. So the court is, for example, I believe that for P2s, the requirement still is that English and French is a must. But from what I gather from the guidance given for judicial fellows on the court's website, really good knowledge of one is necessary, and a good knowledge of the other, or an understanding of the other, is encouraged. So you see, there are slightly different requirements for these two positions.
Yeah, I would, just to jump in there for a second, I would definitely echo that, and I would say that I think maybe the best advice to prospective applicants is to really try to, you know, present yourself in a way that is going to help you clear that first hurdle, especially. I think just in terms of transparency, I think that often the internal process of the university is more competitive than, let's say, the actual process once the applications get to the court, right? Because, you know, you could be, if you're at Yale Law School, you could be against, you know, 30 other Yale students who have very similar sort of, you know, everyone has great grades and this and that. And, you know, so you need to think about how you can get the edge in that context. And, you know, I think that oftentimes, as Beatrice was mentioning, it'll be LLM or SJD students who are selected from, you know, the Anglo-American universities. And, you know, that will be because they've had sort of more of an interest or access to some of the more traditional public international law opportunities, like, you know, working in an international organization, studying public international law in more than one or two courses, and those types of things. So, you know, you need to think about that. You need to think about, and I think that, you know, if you're going to be applying from an extremely competitive, let's say US-based or UK-based school, that I think maybe should be your main concern. And then, you know, also, of course, trying to think about how the court will view you after that. But I do believe that in most cases, I think that, you know, if you wanted to sort of add something to your application or modify it a little bit after you've been selected by your university, I think that there's no problem with that, generally speaking. So, you know, I think about that first step, especially. However, if you're coming from a university that doesn't have a particularly competitive internal program, then yes, you should be thinking more about sort of the perspective of the court. And as Shashank mentioned, I think that publications and the writing sample itself is really key. One, you know, there's different ways that you can try to set yourself apart, and there's sort of some advice we can give. I included an English language writing sample and a French language writing sample. If you have it, why not? I think that for the length of the writing sample, I think there's a limit, but it could be good to, you know, try to showcase something that shows obviously academic rigor, but also keeping in mind that, you know, the court is looking for people who are going to help with everyday type of research. So you want to show off a sort of more of a concrete, perhaps, piece than maybe a think piece. And in terms of letters of recommendation, I think that I believe it's two that you're allowed to, you submit letters of reference, but you also can list referees. So individuals who could act as references for you, but haven't necessarily written your letters of recommendation. So that's a chance where you can, you know, sort of add a little bit more to your application. But in terms of the two letters of reference, as was said before, you know, the academic aspect is really key in international law. So perhaps, you know, one academic reference and then one professional reference is always a good rule of thumb. So try to think a little bit about ways to set yourself apart.
If I could just jump in, I thought Shashank made a good point. Something that I think about when advising students about this process is just what Shashank said, that the court, you know, it's an amazing launching pad for a career in public international law, but it's by no means an end in of itself for young people. So, you know, I think what's important is to think about how you want to build sort of your repertoire of things you want to present to the court around a broader sort of process for yourself of entering the field of public international law and developing a career in public international law. So it's worth thinking about sort of how do you want the court, how do you want to leverage your experience with the court? How do you want to make it a part of your larger career path in public international law, if that's indeed what you want to do? And so I say that because, you know, immediately after the court, you know, you'll have go in some direction. And so it's important to sort of keep your options open and develop different areas of your experience that you might be able to further pursue your interest in public international law after the court. And the other reason this is important is because actually the average age of participants in the Judicial Fellows Program, at least in our year, was actually about 30 and a half years old. We averaged it out. And I say that because it means that a number of folks did have experience in a variety of different settings sort of before going to the court. So some had worked in law firms, some had interned in different places. They had maybe begun a PhD or an LLM or something. So, all of that together can contribute to your application. And you can sort of think about sort of how do you want to build in a potential Judicial Fellows experience into sort of what you're already doing on your route to the legal career you want to have. But when I was in school, I if somebody had told me that, I would have said no. Like, I just care about going to the court. I really want to go to the court in particular. But I think it is important to step back and think about how do you want to develop yourself for a longer term career, and I think that is, at the end of the day, is the goal.
Yeah. I can't help but say that given that there's lawyers from Yale and lawyers from Harvard on this show, I have to say that you must note that it was the lawyer from Harvard who talked about extreme competition in law school, and not the lawyers from
Yale. I would
Yale.
like also to jump in a little bit to go back to Amir's commenting. If you have the opportunity to submit a French sample, do it. I did it also. And I also was really selective when presenting my writing samples. As I had a background in human rights and the system in the Americas, my other sample was in English and was about this and was focused on international law there. So also going back to Beatrice's point, try to find your strengths. From your experience, or if you're a student, what have you done? Or for instance, if you have participated in the JESUP, or in my case, I participated in the Shahus at it. I think that that adds a lot to your application. And if you're really young right now and you're seeing the podcast, maybe you can contemplate to participate in one of these moot courts that there are in international law. It will give you a really good knowledge and experience, and it can add it to your application.
Right, that's in fact a very good point. So we know that there is so in the ICJ Judicial Fellowship, there's very diverse experiences, but just as a sort of a rule of thumb, or just to guide the listeners that we have today, what activities should students generally should do during their law school? So for example, by that I mean participating in moot courts, so for example, being editors in law reviews. So what kind of activities should they go for, and anything that you would like to add in this particular point?
Well, just briefly, I think we've touched on a number of the points, but learning languages is always useful at the court. Obviously, French or English if you're a non-native speaker, and other languages as well. I think there's always room to make use of those skills at the court. So I would encourage. I know that many people do try to work on their French as to build up their portfolio when applying to the court. The other thing Camila mentioned, of course, moot courts. There are many out there. The JESUP is very close in nature to the work of the court. So I think that if you've done the JESUP, you'll find that you're quite well prepared in a certain respect. You can also, work on short writing projects where there are a lot of blogs out there. That's another option. The court, I think, will pay attention to writings that you do in international law in general. So really, there's nothing in specific that you must have done X, Y, or Z. It's again, that's why in my opinion, sort of the theme is sort of building your, broader skill set and dedication in the field of public international law. I think that's, at the end of the day, you know, what really helps. And it doesn't have to be just in public international law. Like Camila was saying, she worked more in human rights, or, you know, you can have an interest. You could be more of an investment arbitration sort of person. You don't have to be just focused on the work of the court in particular, but you know, just developing yourself in any of those areas, I think, will pay dividends.
If I could just say something here, because I mean, everyone on this talk at least is from an excellent university where they have great public international law programs. But there's of course lots of people who do not come from universities with great public international law programs. And when I happened to study in India, we had a very rudimentary program. And I guess the thought was that do whatever would expose you to the cutting edge of thinking in international law. And would expose you to, say, what it means to research, how to research public international law, and how to write well. Because, I mean, at least from where I come from, what you consider good legal writing by Indian standards is definitely not good legal writing by what I learned public international law standards. So, I mean, there were limited opportunities within the law school, is the point that I'm trying to make. And there may be lots of people who find themselves in this situation, especially in less developed parts of the world. But that shouldn't also stop you or make you think that you're somehow of a handicap when it comes to applying for the court, because there's so much else you can do. And you should really, as Beatrice said, blog posts, moots were great for the Indian setup, for example, really allowed you to delve deep. Yeah, so if your university doesn't have a program, it's still, I think you should still get exposure by doing these things.
So Shashank, if I can jump in, and I'm really glad you bring this up as well, given that, you know, students who belong from the global south or developing countries don't have as many opportunities and do not have as much access. So I think this question's probably geared a bit towards you and Camila as to how maybe your personal experience help with overcoming that issue of access and opportunity, and what you did differently, and what other recommendations you may have for students from the global south.
I mean, I guess the shortest answer to that is that, and I mean, it's kind of, well, I mean, the short answer to that is the fact that I was able to go to the court because I went to Yale Law School for an LLM. If I did not go to Yale Law School for an LLM and I just did my legal studies in India or at any other university in India, it would have been practically impossible for me to go to the court. So yeah, Yale Law School made it happen, and a lot of other great law schools make that happen. So that's one answer, I guess, in terms of how practically it works. A lot of the people from the global south actually end up going to the Judicial Fellowship program, and in fact entering the field of public international law generally through these established institutions that serve as gatekeepers of the field of public international law. Both a good thing and a bad thing, I guess. It has been argued in scholarship. Not going to take a position here, but to the extent that it increases the diversity of international law, it's a great thing that these institutions continue to offer these opportunities to people from the global south. Of course, they still serve and exercise some amount of control in serving as then gatekeepers as to who's allowed to go through and who's not. And then you could argue that not allowing somebody who hasn't studied at one of these universities to not go to the court because, say, their university can't fund it is a major impediment. So I do really feel that funding is a major problem. We had people who had very sort of different amounts of funding available to them. So again, you have law schools with great endowments like Harvard and Yale, who have well-established programs, who have a stipend that I think is fixed and it's indicated before you apply. Others I know from my year that came from the developing world had to negotiate with their universities, and it wasn't always clear as to how much money they'd be getting or if they'd be getting any at all. And sometimes they had to sort of make ends meet from their own pocket. So those were difficulties that people had to go through, and I think that continue and can only be alleviated by the court offering some sort of support for greater diversity.
And Camila, maybe your input on that as well?
Yeah, of course. Yeah, in my situation, I guess I could have, and I wouldn't be able to have this experience in the court if I hadn't had the sponsorship from Stanford. However, I do remember a small talk that I had, a conversation that I had with President Yusuf, and I still have it in my mind, and I still think that there is a lack of advocacy for this program in Global South universities. I don't think that it is not impossible to access from a Global South of university. The fact is that sometimes maybe the universities don't focus in sending their students to the program. And he mentioned that one university in Colombia used to send students directly to participate in the program. So I think that that's really valuable, and it touched me because I actually am trying to connect with universities here to start seeing how you can send students from advanced programs, master programs, or PhD programs to participate in the program. Because I do believe that diversity comes from, from also advocating in your own countries to promote the program.
There was a Colombian fellow with me in my year from a Colombian university, I believe, Camila. So.
Yeah, if all of you could also perhaps, like Shashank mentioned right now, talk about other fellows in your own batches, and maybe if you are aware or if you remember anybody, what was the sort of representation like at the time? What were their backgrounds like as well? Because indeed there is a bit of a pattern where Shashank mentioned this concept of gatekeepers, where there are certain sort of specific kinds of schools or universities from specific regions, which make up the large majority of judicial fellows as well. So if you could provide a little bit of input as to your experience at the fellowship itself.
I don't have numbers right off the top of my head, but again, you can go on to the court website and pull up the alumni and take a look. In our year, we had colleagues from Ukraine, from Germany, from Bulgaria. I'm going to forget, but many students, it is true, they have tended to do an LLM or higher level study in international law, and it tends to be that's the school that ended up sponsoring them. And so that's why I mentioned yes, the initiative that Judge Yusuf has proposed at the UN. It's just so important, and we can only hope that it will be taken seriously. And we can also only hope that if anyone is listening to this podcast who's sort of a practitioner or working in an NGO or something, that you'll be interested in potentially seeing if your organization could sponsor a fellow. I haven't ever heard that suggested before, but it is just so, it's just such a tremendous experience to diversify the program, and it'd be money well spent in my opinion.
Yeah, on that was something that we had thought about, and it seemed to us that there'd be a minefield of conflict issues there if people with vested interests started sponsoring. But again, you win some, you lose some. You have both sides of the story.
Right. So moving to the ICJ phase of the fellowship now. So maybe we can start with Amir, and then everyone else can feel free to pitch in. So Amir, could you give us sort of an understanding of the life cycle of a case at the ICJ, and perhaps maybe tie in the work of a judicial fellow at each of these phases?
Sure, I'd be happy to. And of course, I guess one of the important things to note here is that just like the application process was sort of university dependent, judicial fellows' experience at the court will often be judge dependent, because each judge has his or her own style of working, etc. So that's something to bear in mind. So I think we'll each talk about our own experiences and our own understanding of the general experience. In terms of life cycle of ICJ cases, it's interesting you bring that up. Actually, we did with ILSA, the International Law Student Association. I did an interview with Judge Donahue a couple months ago, where we discussed in depth the life cycle of a case at the ICJ, from application all the way through to judgment. So if you want details on that, please check it out. But I think the way to think about it is that ICJ cases generally have long lifespans. So when you arrive at the court, you'll sort of realize that there are cases that are kind of in all phases of the life cycle. So, when we arrived, I believe that sort of the Chagos advisory opinion, the hearings had already concluded. And so the advisory opinion was imminent thereafter. So we got in sort of towards the end of that. There are other cases that were pending, but for which we really didn't have much work to do on them because, for example, it was in the phase, the written pleadings phase, and so each state would have 6 months or even maybe up to a year for their memorials, counter memorials, reply, rejoinder, etc. So to give you an idea, a typical case could last anywhere, I think, from, of course, it depends whether there are preliminary objections or provisional measures or other things that would sort of delay the proceedings. But I'd say a typical case usually lasts a minimum of 2 or 3 years at the court and can last for quite a long time. I know that there are some cases, you can check the list of cases on the court's website. There are some cases that are pending, have now been pending for perhaps at least over a decade. So that really depends. But the sort of unique thing about arriving and having a 1-year snapshot of the work of the court is that you'll end up sort of seeing these different cases at different moments in the life cycle. So as I said, Chagos was reaching an end. There were moments when we were at the court and an application would be lodged by a state trying to bring a case. I believe that happened maybe on 2 occasions while we were there in 2018, 2019. So that's very exciting. So you see, oh wow, a new case has arrived. What's going to happen? Will there be provisional measures? What will happen, etc. And then we also had the occasion to see, I believe, we had provisional measures hearing while we were there and order. We had preliminary objections, I believe, hearing and judgment. I'm trying to think if we had something on the merits, but it's going to really depend on the timing of when you're there. But given, that being said, with the ICJ's docket being as full as it is these days, with something like 15 cases pending, in any year will definitely be busy. And I think if you've just, for example, if you sign up on the court's website for the press releases, which you can do, and I recommend that you do to keep abreast of the court's work, you'll notice that in the past several weeks, the court has been extremely active. I think now they're in the midst of maybe the 3rd set of hearings in the past month or so. So that's something that will really depend on the year when you're there.
I guess 9 months is also a really short time if you think about it in comparison to the lifetime of these cases. But one of the good things is that because there are so many cases, you can happen to see different stages and different disputes within those 9 months, because the court is busier with some stages, and is more involved, of course, than in others. Rule, it just depends upon your judge and your rapport with the judge and how comfortable they are trusting you and giving you work.
Shashank, I'm really, really glad that you bring that up as well. So perhaps also you can provide some more input, and so can all the other participants, as to how do you distinguish then the work of a judicial fellow from the legal staff at the ICJ or an associate legal officer? Because indeed there are so many concurrent lawyers present at the ICJ working for the staff, and then indeed with the judicial fellow as well. So maybe if you could also provide us some information about following each step of a judicial fellow. How does it pan out over the 9 months?
So I guess in my experience, I happen to be in a position. So as you can well imagine, once you go to the court and you're new to the court and you already have a P2 who's been assisting a judge and working with them closely for say 1 or 2 years, the judge is obviously going to count on that P2 more and trust that P2 more. And the judicial fellow is going to be given smaller tasks to ease them into it and to see how they're at it. But I guess if you successfully transition through that phase, in my case, I worked seamlessly in a team with my judicial fellow. It was like a nice cohesive unit with my judge and my P2 and myself as the university trainee. And we worked as a team. And by the end of it, I mean, of course, the P2, of course, is more experienced and has greater insight into the practice and procedures of the court. But by the end of it, in terms of legal work, we were at a place where substantively we were discussing every legal issue and we were open to each other.
Look, I'll just say briefly that, you know, we're saying that the experience depends so much on which judge you're working for, and it can vary quite tremendously. But I think that there are a number of really, you know, incredible opportunities to be had, no matter what your working relationship is with your judge. Often, you know, you will actually have, you know, compared to sometimes compared to a domestic clerkship, you know, it's not the case necessarily that your phone's going to be ringing off the hook every 2 minutes, that someone is asking you to produce sort of just basic sort of materials and emails on things left and right. So with that becomes, it's actually quite like an incredible freedom in a certain sense to work with your judge on sort of sometimes, again, depending on the situation, deep dives into particular legal issues that are really quite complex. You sometimes will work on you know, you'll often work on a memo for each and every case that is coming before the court. Sometimes you'll be working on sort of evidentiary issues. So actually, one of the interesting things about the court is that it's both, you know, sort of a trial court in nature, a court of first instance, but it's also an apex court. So you'll have a nice mix of high-level legal issues, maybe about treaty interpretation. Maybe you'll write a memo about that. But at the same time, maybe you're working on, you know, making a summary of the factual record and sort of points in dispute. So it can be you know, the tasks can vary quite a lot. There are many different types of work that you may do, but I think what's exciting is that the court has so many different sort of opportunities to participate, because as Amir was saying, the cases are so long. And like I was just saying, the court sort of has it sits in sort of different capacities, even within one case in particular. So there's, you know, there's really interesting work all around to be had. And I found the experience quite rewarding in that, you know, you're able to dive in and to make the most of learning as much as you can about the substance of the case before you, the procedure, and all of the sort of sub-issues that come along the way, which are often quite complex and you may not have studied in law school. So you get to dive into sort of the mechanics of how is a case kind of flowing through the court, and what are the fault lines and the pitfalls and how it moves through the court through the different procedural phases.
So Beatrice, if I could just quickly jump in and ask, you mentioned working with a judge, and I understand that this question again is probably quite judge dependent and differs from person to person, but how much face time should you expect with a judge on average? What is that level of interaction? Is it like a sort of mentor-mentoree relationship? Is it quite direct in that nature? Maybe if you could also just provide some insight into that.
Sure. So I think that a lot of the judges do make quite an effort to mentor their judicial fellow. It's going to vary quite widely. It's not necessarily a day in and day out relationship. Like I was saying, in the sense of a domestic court clerkship, you know, you're kind of constantly in conversation with your judge. But you know, you will have assignments. You will discuss your assignments. You will you will work with your P2. You're going to have. I think you're going to have develop a very meaningful relationship where you're going to have opportunities to present, to work with the judge on his views. Perhaps you'll be able to present your own views and really have an interesting substantive back and forth. That's my experience. I don't know if others would want to chime in.
I would just add one thing, that as Beatrice mentions, so the day-to-day with the judge and your team will vary depending on the team, of course. And there were some judicial fellows who were extremely busy, I would say. But I would say that the majority of fellows sort of had a nice amount of work, which left a little bit of room for the fellows to sort of take initiative on various things. So when I say that, I mean, on the one hand, there's taking initiative within the context of the court's work, right? So, you see an issue, you flag it for your judge or your P2, for your fellow judicial fellows and, dive into it, look into it. And I think that was one of the most memorable and rewarding aspects of the program. I mean, I have these vivid memories of sort of Beatrice coming in to my office with her cup of tea and saying, did you notice this thing? And, it prompts a debate. So, really, I think that the program, the title fellowship is really accurate now. And I think that that's part of why they changed it, because, you're there to kind of self-motivate and undertake, you're there to assist the court in its work, for sure, but it's also a year that allows you opportunities to sort of explore whatever it is you want to explore. You're sitting in the Peace Palace, where you have, not only do you have the library of the Peace Palace, which is a huge resource, but there's also the library of the ICJ itself. And between those two resources, there is not a single source related to international law that they cannot get you, within 24 hours. So you're sitting there with, a nice desk, beautiful view of the gardens of the Peace Palace, all of international law at your fingertips. So it's a year that, you can use to, in your free time, work on publications, explore different things. Beatrice and I, along with another judicial fellow who's currently a P2 at the court, Tim McKenzie, we co-authored, for example, the Jessup problem from last year. There's all kinds of things you can do, and The Hague is also a place that's full of young international lawyers doing very interesting things at a wide range of tribunals. As you know, Faris, from living in the area, there's a lot of opportunities. So it's a year that you should think about when you're going to the court. You should think, okay, well, these are my goals for my work with the judge and at the court, and you have to, bear in mind that you're going to need to be a little bit flexible depending on the style of your judge. So, you need to then also maybe have some personal goals related to your academic interests or professional interests, etc., that maybe you want to pursue during that year.
Yeah, I think you sort of evaluated the experience of the year really well. So moving towards the conclusion phase of this episode. So Camila, starting with you, how would you what would be your evaluation of your experience or your year at the International Court of Justice? And sort of, if you could just give us an explanation of how this has helped you in going forward in the trajectory that you set out for your career.
Of course. Well, the ICJ program for me is, I can just say it was really magical. Looking it by, like right now, looking it with different eyes, I think that it was, as Amir mentioned it, it's a really, really special place to be there. It's a once in a life opportunity if you don't become a P2 or maybe a judge. So being not only in being in the Peace Palace, sharing with the people that you have around, because most of the people have the same interests that you do and are curious about the things that you care. And so the conversations like escalate in different levels. And also the Hague is a magical place. It's quiet, it's romantic. It allows you also to have time for yourself and maybe to think about what next step you would like to take in your life and to reflect about your life. Sometimes, you live in busy cities and you don't have that kind of time. Living in the Netherlands is also, the Netherlands is a really easygoing country for international people, and to adapt is easy and fast. And also you have all the tribunals. So yeah, it was really magical. And regarding the next step in my career, I took a while before I decided to choose what I wanted to do. I actually didn't have any plan afterwards. And I applied to multiple jobs, but when I had some offers, I I also was really selective to do a next step because I wanted to continue in the career of international law from the human rights point of view, or from a more public interest. It was a public, like more in a global framework. But it's a really competitive scene. However, I can say that it has leveraged and potentialized my career to other spectrums of the law, because right now maybe my profile can be considered to other practices of law that before wasn't. So yeah, for me it was a tremendous experience. I really value the people that I met and the time that I had there.
So
Thanks for that. Maybe we can go to Shashank.
Yeah, I guess magical is the right word to use it for it, isn't it? Those 9 months were absolutely magical. I mean, Amir mentioned the setting, which is of course the Peace Palace and Dutch cafes serving good breakfast and all of that, where you can just go. But I guess more important than all of that was also just the people that you were surrounded with, an exceptional community of individuals, some of the sharpest legal minds from all across the world, and nicest human beings, of course, also, that you could find that care deeply about the same issue, and most often with an open mind. I mean, I remember Amir mentioned that they happened to write the Jessup problem. In my case, it was a different realization. Sitting in a hearing, realized that all counsel that appear before the court are usually of the same ilk and come from the same invisible college. So ended up working together with the P2 that year and writing an article on the demographics of the ICJ bar, talking about how sort of Western it is, etc. Had great discussions with people at the court. I mean, of course, those people would never acknowledge the fact that they would ever publish that or whatever, but just people are there with an open mind. If you have a sense of trust, you can really discuss and get ideas about so many things under the sun, take them forward with your own initiative, as Amir mentioned. I happen to, in terms of concrete next steps, take a step that is quite par for the course for people who go to the court, which is basically move to the Iran-US Claims Tribunal, which also happens to be another international institution, another international tribunal stationed in The Hague, a short walk down from the court. So I worked for an American judge at the Iran-US Claims Tribunal. A lot of the judicial fellows before and after me have also taken that path. I worked there for a while. I was pretty sure by the time that I left at the court that I definitely wanted to pursue a career in public international law. And again, for me personally, going back to India was not an option at that time, because there was just no public international law at that time in India. Nobody was practicing it. And so I had to find ways to stick around. Used to go back for a couple of months and then come back and try and find internships, etc. And then eventually the WTO came through, and I got a job here, working as a dispute settlement lawyer, still continuing in the field of public international law. And I guess in hindsight, another thing that I really like is the fact that I've had the experience of all of these courts and different institutions, because international law can also be really fragmented, as we all know. And dispute settlement especially coalesces around communities that are repeated actors in those fields, So just having a trip through all of these different fields has been a privilege. Yeah.
Right.
Yeah.
So Beatrice, yeah.
Sure. Yeah. I mean, I thought the experience at the court was just really tremendous. One of the things I think that, you draw so much substantive knowledge during that year, just from being at the court, following the cases. You think about so many things that you didn't have time to think about in just one or two international law courses in the law school setting. So I found that being at the court and studying the cases and doing the work really opened up a lot of new avenues of thinking about a whole host of issues before the court that I never thought about before. I didn't know provisional measures. Provisional measures are now, really obviously famous because of Gambia v. Myanmar case, but like looking at it through with a nuanced lens was something I'd never done before, thinking about how the court's law and practice has evolved over time, thinking about how the judges differ in their approaches to treaty interpretation or something. These are all things that I hadn't had an opportunity to really focus on before. And so I really found the experience just tremendous in that respect. And talking, going to work every day, we get to talk to 14 of your great friends who also love public international law and who are really knowledgeable. It's just such a rare experience. And one that, really is what helps to make you a better lawyer and more knowledgeable about the subjects at the court. So yeah, I can only echo what Camila said about it's a magical experience. You do have to make the most of your time while you're there. And I echo Amir's point entirely that, you have to be flexible in all aspects of the work and really try to, set goals for yourself and make sure that you're doing what you can to make the most of the experience and learn as much as you can, because it's such a privilege to be at that court that, you want to walk away from it feeling like, you're that much closer to your goal of being a public international law practitioner, if that's what it is, or scholar, or, what have you. So that's my take.
Right. So Amir, any parting thoughts before we end the session?
Let's see. Well, I just have to echo everything that's been said in the past few minutes about all the tremendous aspects of the program. I think something, the peers, the setting of being in The Hague, the time it allows you, the doors that are then opened for the international law profession and individuals' careers it really can't be underestimated. I think that I felt that in the past year or so with that experience from the ICJ, because these institutions often feel like a black box from the outside that you don't really understand how they work. But then once you have that sort of inside understanding, it really is helpful for you in your career in international law going forward. And of course, the conversations you have with your judges, who I think one of the best aspects of that is that, it's the generational difference, right? So my judge was is currently the oldest on the court. And, I remember on the first day when I sat down, he was telling an anecdote about the work that he had done on the Barcelona traction case. And, it was kind of mind blowing for me sitting there as a young international lawyer at the beginning of my career, to be able to have that kind of interaction with an individual like that. And I think that is sort of emblematic of what the court is. It's really just a sort of a wealth of knowledge, and it's there for you to sort of tap into during your year. And so I think my parting words then would be for individuals not to be afraid to sort of really actively apply for the program. I think that alumni have a role to play to encourage their universities to value the program, to talk about the program like we're doing now. Students who are at universities that haven't previously participated in the program should not be shy to reach out to their deans, to professors, to try to get the program running. And then, of course, if the trust fund becomes up and running, that would also provide an opportunity there. But I think that the program is, to go back to what Shashank said at the beginning, it started as a very sort of organic, non-formalized thing that has grown into an institution, and that's really because of the people who have supported it and participated in it and continue to try to build it up. So we would encourage everyone to apply to the program and participate.
And on that note, we end this episode. Thank you everyone for taking out the time and joining us for this insightful session. And yeah, we'll see you in the next episode.
Yeah, absolute pleasure to have everybody. Thank you so much.